Hello everyone, welcome to Courts Today by LiveLaw. I'm Debojeet and we have quite a lot of ground to cover today. From crucial development in the Akola riots case to the high-profile cases involving the likes of Jawed Habib. So, let's begin. Starting at the top were hearings of the petition filed by the Association for Democratic Reforms in respect of the ongoing special intensive revision of electoral rolls continued, and lawyer Prashant Bhushan submitted that the ECI should use a de-duplication software to identify multiple entries of the same person in the voter list. The bench of Justices Suryakant and Joy Mallya Bagchi responded quite positively. Justice Kant remarked that the suggestion was a good suggestion, that there should be no problem with that. The court asked how the software might be implemented, urging the ECI to consider the idea. Beyond deduplication, the ADR also asked that the ECI be directed not to determine citizenship during the SIR, since the poll body does not have that function. Justice Kant flagged this issue. If they have power, they will determine. If not, they will not. The issue will arise in the final matter. There was also discussion about making the electoral rolls machine readable for easier verification by voters, but the court and the ECI flagged data privacy concerns. Justice Bagchi noted the risk of data mining if the lists were published in a fully searchable format. The court directed the ECI to file its response and posted the matter for further hearing. The next date is set for 26th November 2025. Moving on to our second story and staying at the top, where Supreme Court turned down a bail application by an individual accused under the Unlawful Activities Prevention Act for allegedly promoting the ideology of ISIS and being a part of a terror conspiracy. When the case came up, senior advocate Siddharth Dave told the bench that today is not the best morning to argue this case after the events of yesterday, referring to the recent blast in Delhi. Justice Mehta's reply was, best morning to send a message. The bench of Justices Vikram Nath and Sandeep Mehta noted that although the petitioner was in custody for over 2 years, 19 out of the 64 prosecution witnesses have already been testified, pointing to the depth of the investigation and the seriousness of the charges. Justice Nath added that incriminating materials described as inflammatory were found in the possession of the accused. Crucially, the court directed the trial court to conclude the trial within 2 years, requiring both prosecution and defense to cooperate fully. Moving on to our third story, which involves an advocate who approached the Supreme Court of India challenging his arrest by the Haryana police in connection with a murder case, claiming that the detention was a coercive attempt to extract information about his clients. The lawyer in question, Vikram Singh of Gurgaon, was arrested on October 31st and remanded on November 1st in the FIR tied to the death of a man named Suraj Bhan. He says the investigation officer had summoned him under Section 41A of the CRPC, seeking disclosure about his clients, and when he went to the station, he was arrested instead. His plea, filed under Article 32, argues that the arrest was aimed at intimidating the bar and undermining the independence of legal practitioners. As the petition states, the manner of arrest reveals a calculated attempt to intimidate and punish a member of the bar for fearless representation of his clients. The Supreme Court has agreed to list the matter for urgent hearing, emphasizing the serious constitutional question at stake: whether an advocate can be arrested in question with client representation without risking the right to fair legal process. Our next story of the day is from the Supreme Court again, as it temporarily stayed the directive to set up a special investigation team comprising both of Hindu and Muslim senior officers to probe the 2023 communal riots in Akola, Maharashtra. Originally, a 2-judge bench had required the Maharashtra government to form an SIT after finding serious lapses in the investigation of an assault during the riots, including failure to register a timely FIR. When the state sought review, the court delivered a split verdict. One judge held the directive was necessary for transparency given the communal nature of the case, while another thought mandating religious community composition raised fresh questions about institutional secularism. In the stay order, Chief Justice B.R. Gavai and Justices K. Vinod Chandran and N.V. Anjaria asked the parties to respond within 4 weeks and suspended the paragraph of the earlier judgment directing the specific composition of the SIT. Next, we move towards Central India, where the Madhya Pradesh High Court held that even if someone dies while unlawfully crossing railway tracks, the Indian Railways can still be held liable if it failed to take sufficient preventive measures. In the case at hand, a 3-year-old child and 2 women were killed when they ended up on the tracks and were run over by a train. The Railways claimed the victims were crossing tracks unauthorizedly and denied liability. But the High Court said that when the crossing was easy, even a 3-year-old could access the tracks. It exposed a systemic failure of the railways to restrict access. The bench emphasized that absence of fencing, barricades, Proper announcements or security on platforms cannot be brushed aside, the court observed. Where passengers cross tracks due to absence of sufficient preventive measures, the administration cannot escape liability on the ground that the victim crossed in an unauthorized way. So in short, this ruling pushes the responsibility onto the railway authorities to proactively secure tracks, especially at stations. Unauthorized access alone won't absolve liability if the infrastructure and safety measures are lacking. The judgment is a critical check on institutional neglect and a nod to accountability in public transport safety. Next to the neighboring state of Chhattisgarh, where a case arose from a news story published in the Dainik Bhaskar, a miserable reality check. It was at a government composite office building in Chhattisgarh. The lift had been out of order for a long period and they lacked basic amenities. For context, this building houses disabled staff, pregnant employees, and others who need accessible infrastructure. And yet they left struggling due to non-functional lifts and no alternative arrangements. The court noted that the staff was enduring extreme physical pain just to get to their workplace. The bench emphasized that this is not mere inconvenience but a breach of rights. Despite clear obligations under standards and laws to provide accessible facilities, the government had not taken basic preventive measures, such as repairing the lift, installing ramps, or providing ground floor options. The court demanded a personal affidavit from the Public Works Department's secretary detailing why the lift is non-functional and what remedial steps are being taken, along with what timeline is being fixed to make the building accessible. In short, the Chhattisgarh High Court has sounded a ringing alarm that when infrastructure fails for the most vulnerable, disabled, and pregnant employees, the state's inaction amounts to more than deficiency. It's a violation of dignity and rights. Next, we have the Jawed Habib case, which took a sharp turn this Monday when the Allahabad High Court granted him and his son interim protection from arrest in a multi-crore alleged investment fraud involving over 30 FIRs. The father-son duo had been swept up in efforts around a company named FLC, or Follicle Global Company, where investors were allegedly lured with promises of high returns, ranging from 2 lakh to 20 lakh rupees, at a seminar held in September 2023 in Sambhal, UP. When payouts never materialized, the complaints piled up. The legal team argued that the investigations were still underway and that arrest at this stage would be premature. The bench of Justices Siddharth Verma and Achal Sachdeva accepted this, staying any coercive action until the police filed their charge sheet. And for our final story today, a 27-year-old accused was seeking bail after being arrested for possession of 18.5 kilograms of hydroponic weed. Although the quantity was below the commercial quantity threshold under the Narcotics, Drugs and Psychotropic Substances Act of 1985, the court refused bail. The bench led by Justice Anil Kumar Upman highlighted several aggravating factors. The substance was highly potent, imported via a sophisticated method, and valued at around 18 crore rupees, which pointed to involvement in a large, well-funded trafficking syndicate, not just a minor user or peddler. The court also flagged a worrying trend: traffickers deliberately keeping quantities just below threshold limits to evade stricter prosecution under Section 37 of the NDPS Act. It held that granting bail under these circumstances would undermine the legislation's purpose of curbing major drug trafficking. Though the recovery was technically under the commercial quantity mark, the potency, value, import method, and syndicate angle convinced the High Court that bail would send the wrong signal. The accused remains in custody as of now. That brings this episode of Courts Today to a close, but if you want to access detailed coverage of all the stories mentioned here and more, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law. I'm Debojeet Das. Thank you for watching.